In criminal law, the duty to retreat, or requirement of safe retreat 550 is a legal requirement in some jurisdictions that a threatened person cannot stand one's ground and apply lethal force in self-defense, but must instead retreat to a place of safety 549-554. It is a specific component which sometimes appears in the defense of self-defense, and which must be addressed if defendants are to prove that their conduct was justified. In those jurisdictions where the requirement exists, the burden of proof is on the defense to show that the defendant was acting reasonably. Elements of acting reasonably include that the defendant had first avoided conflict and, secondly, had taken reasonable steps to retreat and so demonstrated an intention not to fight before eventually using force. U.S. law. Some U.S. jurisdictions require that a person retreat from an attack, and allow the use of deadly force in self-defense only when retreat is not possible or when retreat poses a danger to the person under attack. The duty to retreat is not universal, however. For example, police officers are not required to retreat when acting in the line of duty. Other states apply what is known as the castle doctrine, whereby a threatened person need not retreat within his or her own dwelling or place of work. Sometimes this has been the result of court rulings that one need not retreat in a place where one has an especial right to be. In other states, this has been accomplished by statute, such as that suggested by the Model Penal Code. Still other states have passed stand-your-ground laws that do not require an individual to retreat and allow one to match force for force, deadly force for deadly force. Most state legal systems began by importing English common law such as Acts of Parliament of 2 ed. 3, Statute of Northampton, and 5 Rich. 2 of 1381, Forcible Entry Act 1381, which imposed criminal sanctions intending to discourage the resort to self-help. This required a threatened party to retreat, whenever property was involved and resolve the issue by civil means. Today, the majority of American states have construed their statutes of forcible entry, both penal and civil, in such a manner as to abrogate, i.e. abolish, the common law privilege to use force in the recovery of possession of land. In Irwin v. State, 1876, the Supreme Court of Ohio wrote that a true man, one without fault, would not retreat. In Runyon v. State, 1877, the Indiana court rejected a duty to retreat, implying it was un-American. 551-2 writing of a referring to the distinct American mind, the tendency of the American mind seems to be very strongly against a duty to retreat. The court went further in saying that no statutory law could require a duty to retreat, because the right to stand one's ground is founded on the law of nature, and is not, nor can be, superseded by any law of society. English law. In English law, the focus of the test is whether the defendant is acting reasonably in the particular situation. There is no specific requirement that a person must retreat in anticipation of an attack. Although some withdrawal would be useful evidence to prove that the defendant did not want to fight, not every defendant is able to escape. In R.V. Bird, the defendant was physically attacked, and reacted instinctively and immediately without having the opportunity to retreat. Had there been a delay in the response, the reaction might have appeared more revenge than self-defense. Carrying weapons. As to carrying weapons in anticipation of an attack, Evans v. Hughes held that for a defendant to justify his possession of a metal bar on a public highway, he had to show that there was an imminent particular threat affecting the particular circumstances in which the weapon was carried. Similarly, in Tailor v. Mucklow, a building owner was held to be using an unreasonable degree of force in carrying a loaded airgun against a builder who was demolishing a new extension because his bills were unpaid. More dramatically, in A.G.'s reference, No. 2 of 1983, Lord Lane held that a defendant who manufactured 10 petrol bombs to defend his shop during the Toxteth riots could set up the defense of showing that he possessed an explosive substance for a lawful purpose if he could establish that he was acting in self-defense to protect himself or his family or property against an imminent and apprehended attack by means which he believed to be no more than reasonably necessary to meet the attack.
Please subscribe and thanks for watching.